today's conversation, we'll take a look at a legal test that's causing shockwaves through the regulatory landscape, and that is the Major Questions Doctrine. Hello and welcome to Talks on Law. I'm Joel Cohen. Lisa Heinzerling is a professor at Georgetown Law Center. Professor, what exactly is the Major Questions Doctrine, and when was it first established?
It's been in the kind of air for about 25 years. The court in a few cases in the 90s referred to questions as being particularly important, in particular in a case involving the FDA's attempt to regulate tobacco. The court referred to the economic and political significance of the question and suggested that they thought Congress would speak pretty clearly if it had wanted the FDA to regulate tobacco. And that's the way the matter stood for a while. It certainly was nothing like a doctrine. It was just offered as one additional argument for a particular statutory outcome.
Interesting.
Now, with West Virginia and arguably a couple of cases involving COVID measures where the court also rejected what the agencies did, now the major questions idea has been elevated to what's known in the jargon as a kind of clear statement principle. And that is that the court starts off by asking, is the statute clear? And if it's not clear, then whatever position is being argued on behalf of the government will lose on a strong enough version of the clear statement principle like the one embraced in West Virginia. So the idea is that the court basically is looking, is this a big question? Is it a question of economic and political significance? And if it is, it's just going to look at the statute and say, is it clear? It doesn't do the same kind of statutory analysis it would do in other cases, analysis of the language and history and structure of the statute in question. This doesn't do that. This really gets the court off the hook. They look, they sort of eyeball it and say it's a major question, and then at that point, they're looking for extreme clarity.
What does that mean? Is it clear? That seems, in and of itself, the test seems pretty broad.
I can't help but say it's not clear, right? It's just not clear how much clarity is required.
Why don't we look at how major questions can be applied to the West Virginia case?
Yes. So what the court did is figure out first, was this a major question? This question of deciding to enact emission reductions at power plants by looking in part at the potential of shifting electricity from coal to other kinds of power plant sources. And so the court said, yeah, that was a major question. It was a major question. I think the court has at least 6, maybe more factors that it cites, a quite complicated multifactorial test for deciding whether something was a major question.
Is it worth running through and cataloging those?
Well, it has to do with economic significance, political significance, the kind of age of the statute. Is it a long extant statute, the court says? Is it, as the agency acted this way before? Has Congress declined to pass a statute that tackles the same kind of problem in kind of the same way? Is the provision an ancillary provision of the statute, what Chief Justice Roberts called a kind of backwater provision? And then once he found that this was indeed a major question, and so at that point, the court is looking for extreme clarity.
And was the language that was found to be too, opaque or too broad, was that the best practices approach?
Yeah, the language was the best system of emission reduction. And here, Chief Justice Roberts said, well, that doesn't mean anything. Shorn of context, he says, system doesn't mean anything. And so he doesn't find that word clear enough, partly, I think, by just completely abstracting that word from its statutory context.
Under major questions, it doesn't matter whether or not the FDA, it could be FDA, the EPA's approach was brilliant or whether it was effective or needed. All that is irrelevant if it is unclear and a major question.
Correct.